Hi, I'm Curtis Clay, Associate Director with the Texas School Safety Center at Texas State University in San Marcos. The issue of bullying in schools is not a new one, yet it has in recent years come to the forefront of conversations of concerned citizens throughout the world and continues to be an alarming problem for many of our students on a regular basis. Among other services, the Texas School Safety Center provides many trainings and presentations throughout the state regarding school safety and security. It should therefore be no surprise that bullying prevention is by far the most requested during any given month of the school year. Fortunately, here in the state of Texas, we haven't had an extreme case of school violence similar to the tragedy at Columbine High School in Littleton, Colorado. Nevertheless, we have had incidents on a campus where there has been a loss of life, and in many of those cases, it was related to some form of bullying. With the passing of Texas House Bill 1942 during the 81st legislative session in 2011, Texas lawmakers took the issue head on, ensuring that guidelines are in place for policies and procedures to prevent and address bullying in our schools. This bill made amendments to 3 different chapters in the Texas Education Code, all of which affect school districts beginning in the 2012-13 school year. So what does the law say, and how does it relate to you as a school district in the state of Texas? Let's begin with Section 25.0342 of the Texas Education Code, where the original definition of bullying was located. House Bill 1942 moved the definition to Chapter 37 of the Texas Education Code and has made some revisions that we'll talk about in a moment. More to the point, schools now have the option to transfer either the victim or the bully in consultation with the parent or guardian, and the option is available to transfer the student to another classroom or another campus in the same district. This change is significant because schools previously only had the option of transferring the victim, and moving the victim of bullying can potentially re-victimize the student, which is the last thing schools want to do. In order to better educate students regarding bullying, prevention, and intervention, House Bill 1942 amended Section 28.002, requiring school districts to include a comprehensive bullying prevention program into the health curriculum. Now, the health curriculum should include evidence-based practices addressing awareness, prevention, identification, self-defense and response to, resolution of, and intervention in bullying and harassment. As I mentioned earlier, House Bill 1942 moved the bullying definition from Chapter 25 on admission, transfer, and attendance to Chapter 37, which covers discipline, law, and order. And it created Section 37.0832 entitled Bullying Prevention Policies and Procedures. Not only was it relocated, the law made 3 significant changes to the definition itself. Let's talk about those. First, it added Subsection B, which states that conduct is bullying if it exploits an imbalance of power between the student perpetrator and victim through written or verbal expression or physical conduct, and that conduct either interferes with a student's education or substantially disrupts the operation of a school. Next, the phrase expression through electronic means was added to incorporate the issue of cyberbullying into the legal definition of bullying. And third, the phrase severe, persistent, or pervasive was amended to read severe, persistent, and pervasive. This change is significant because it essentially narrows the scope of the kind of conduct that the law considers bullying by requiring that conduct include all 3 elements, not just one. Let's take a moment and look at a tool the Texas School Safety Center has created to help you better understand whether or not conduct is considered bullying as it pertains to the law. This flowchart here can be downloaded from our website. We'll begin with a simple question. Is the conduct written, verbal, through electronic means, or is it physical? If so, we move to the next question. Does it occur on school property, at a school-sponsored or school-related activity, or in a vehicle operated by the district? If it is, then we have to take it a step further. Does the conduct exploit an imbalance of power? The imbalance of power does not have to be physical. It might also be social, psychological, or emotional. If the answer is yes, then does the conduct interfere with a student's education or disrupt the operation of a school? If so, then only one of the last two boxes needs to also apply for the conduct to be considered bullying. Does the conduct have the effect of physically harming the student or damaging the student's property? Or does it place a student in reasonable fear of harm, whether it's to himself or his property? Maybe the conduct is severe, persistent, and pervasive enough that it creates an intimidating, threatening, or abusive educational environment for a student. If any of these are true, then according to the law, the conduct can be considered bullying. And this bullying conduct flowchart from the Texas School Safety Center can help you come to that conclusion. Now that we've addressed the changes to the definition of bullying according to the Texas Education Code, let's look at the policy and procedure requirements of House Bill 1942. First and foremost, your school district policy shall prohibit bullying, which should go without saying. Each of us wants our students and our schools to be safe, and not allowing bullying behavior in our schools is a no-brainer. 2, school district policy shall prohibit retaliation against any person, including a victim, a witness, or a person who in good faith provides information concerning an incident of bullying. What we're talking about here is making sure that our students understand that they will be supported when they do report incidents of bullying in the nutshell. 3, districts shall establish a procedure for providing notice to parents regarding an incident of bullying, which refers to the parent or guardian of both the victim and the bully. How your district chooses to notify parents will vary, including phone calls, emails, text message, certified letter, or even a parent meeting. And they should be notified within a reasonable amount of time, which is up to each school district to define. 4, districts shall establish the actions a student should take to obtain assistance and intervention in response to bullying. In other words, what should students do to get help? Examples might include contacting any district employee using an anonymous reporting system via text or email, or maybe a written or voicemail inbox, depending on what resources the district has available. It's also important to remember this, therefore, that school districts effectively train all employees to assist students when these situations arise. Think about it. Don't you want your bus drivers, custodians, and secretaries capable of helping students get the help they're looking for? 5, school districts shall set out available counseling options for a student who is a victim of or a witness to bullying or who engages in bullying. Basically, what professional resources are available to your students, including district-wide resources, as well as community organizations. And you should also notice that these counseling options are not only for victims, but for bullies and witnesses as well. 6, each school district shall establish procedures for reporting and investigating an incident in addition to determining whether a reported incident of bullying actually took place. One thing to remember is that it is always a good practice to document all reports and investigations. Number 7, put in simple terms, says that after an investigation, if a student is found to be a victim of bullying, she cannot be disciplined for the use of reasonable self-defense in response to the bullying. This is obviously significant for victims and the extent to which they are allowed to stand up for themselves. But it is also dependent on how a school district chooses to define self-defense in their handbooks. Finally, school districts are required to comply with federal requirements, including those under the Individuals with Disabilities Education Act, if a student with disabilities is bullied. Now, the policy and procedures we've just discussed from subsection C must be included annually in the student and employee school district handbooks, as well as the district improvement plan. In addition, the reporting procedures must be posted on the district's website to the extent practicable. You know, we realize that bullying is a very complex and complicated matter that schools often have to deal with, and solutions can be difficult to find. However, we hope that this video has been beneficial to you as you address it in your district policies and procedures, and that you come away with a better understanding of House Bill 1942, Chapter 37, and overall school safety. If you would like more information or training on bullying prevention or any of the topics that we provide workshops on, just give us a call here at the Texas School Safety Center, and we will be more than happy to assist you in any way that we possibly can. I also want to invite you to take a look at our website and look at the resources that are available to you there. This is a great opportunity. The best news of all, it's free of charge, and it won't cost you a dime. Whether you need assistance with your emergency operations plans or getting your staff trained to conduct school safety and security audits or assessments, we are here for you. The Texas School Safety Center at Texas State University, San Marcos. Preparing today for a safer tomorrow.